SJC-13893, Arcangelo, Cella et al. Versus Andrea, Campbell, Attorney General et al.
Okay, Attorney Daly, whenever you're ready.
Thank you, Chief Justice Budd, and may it please the court, Ed Daly on behalf of the appellants. And with me today are my colleagues Elisa Flynn-Poppy and Katie Martin. We are here today because the Attorney General erred in certifying Petition 2521, it's been commonly referred to as the rent control petition, for inclusion on the November 2026 ballot. And that error stems from the fact that the Attorney General said it contained only matters that are not excluded under Article 48. And we have a number of reasons why that decision was erroneous, but I'd like to jump right to the only grounds that this court need to reach to resolve this case. And it's not just because the last case also dealt with religion, but this is truly the only and most narrow grounds that the court need to examine. And that is because the petition, by its very own text, and the fact that religion is a factor in the application of the law, it relates to religion under Article 48. So under Article 48, I'd like to just start with the excluded matters provision and the structure of that provision. It begins with no measure that relates to religion, religious practices, or religious institutions can be included on an initiative petition. And the fact that that is the first excluded matter is not a mistake. That was the focus of the delegates' attention at the Constitutional Convention in 1917 and 1918. And the historical context is important here because this is on the heels of the ratification of the Anti-Hate Amendment. So the discussion at the convention was, how do we keep religion as far away as possible from the political discussion, from the initiative petition process? And so what the
cases don't just sort of end that quickly, right? For example, the sexual orientation case, the SJC concludes it's a matter of religion because there's so much religion in it. Here we have a sentence saying this rent control measure doesn't apply to nonprofits, education, and religious institutions, right? It's basically separating the for-profit world from the nonprofit, or I'm just not sure this is the same. Are there any case like, there are only two cases, right?
Correct.
What's the second case? The facts of one, the sexual orientation, basically out of nowhere, they create all these exclusions for religious entities from all these laws, including race discrimination, sex discrimination, religious discrimination. That clearly has a big, what's the other case?
The opinion of the justices of 1941. That's the contraceptive case where the analysis there is, can a law that is secular in nature, can that still be, is that still including the religious matters or potential to relate to religion, religious practices? And in that case, there's factors that the court set out where even, and this is the reason why the court said that it did not relate to religion, is because religion was not mentioned in the text of the petition, and religion was not a factor in its application. So that sets out the limit of a test where
so anytime you use the word religion and any reference to religion whatsoever immediately knocks you off the ballot?
Well, here it's not just a reference to religion. Religion is the operative factor in determining whether rent control applies to a particular unit or not.
Well, it's religion, education, I can't remember the nonprofits. Basically, this group of entities that are not sort of classic landlords making money on rent. I think we're extending the religion exemption pretty broadly if we do that, aren't we?
I think this is sticking exactly within the religious exemption, and the inclusion of the word religion and the exception for religion had to have some purpose. Statutory construction.
What purpose does it have beyond nonprofit?
The proponents included religion being different from nonprofits.
I don't know what they did. I'm just asking you, what difference would it make? I mean, as far as I know, most religions are nonprofit, maybe all.
The difference is important from why the exclusion exists, why the religious matter exclusion exists, because it could give rise to public political debate about whether religious institutions are being advantaged, how they're being treated under the law. And here, religious institutions or religious uses units used solely for religious purposes are given a benefit under this proposed law that other secular uses would not be.
It seemed to me that exactly what Justice Kafker said, which it looked like this subsection D in the initiative petition was designed to delineate between the profit or commercial owned properties and operated properties and those that are not, that are not commercial, that they're nonprofit. And I actually don't even think they might have needed educational or religious. They may have just been able to say nonprofit, because that would have included the educational and religious properties as well. So I'm not sure that in this context, the word religious carries much weight at all. And I think this is really the nub of the question, which is if it doesn't really carry that much weight, then how does this initiative petition fall into an excluded matter, which is clearly designed to get at things that go to the practice of religion, the establishment of religion, actual religion, as opposed to this kind of nonprofit building. It's the use of the building.
A couple of things, Your Honor. First, the purpose of the exclusion was not to prevent laws that targeted religion, that benefited or burdened religion, or somehow impacted free exercise. It was only to prevent, and this is a categorical exclusion, to prevent the possibility of discussion about religion infiltrating the initiative process. So it's a different concern that the delegates of the convention had that make this particular exclusion particularly broad. And so that a law that just uses religion as a factor in its application, and this is directly from Collins and the opinion of the Justice in 1941, when you use religion as a factor in its application, that alone makes it an excluded matter.
But how do you? I guess the harder part that I'm struggling with is if you marry the 2 points from Justice Kafka and Justice Wolohojian, the AG counters that. This is an exemption for educational, religious, and nonprofits. It's not a religious exemption, a standalone religious exemption, right? So doesn't the presence of all of these two other kind of secular comparators, doesn't that do something for this? Doesn't that reduce the risk of this kind of sectarian political debate?
It doesn't.
How?
It doesn't, because religion must have had some purpose and intention of being included, because that's what the proponents chose to do. They chose to include religion. If religion is just read out of, the court can't do this, just reading out religion that's included in this exception to determine whether a unit is covered or not, that would be the only reason, that would be the only way to get around the fact that it is there in the text of the petition.
Do you think a voter really thinks that this rent control is going to lead to a lot of discussion about religion and religious benefits, particularly when every nonprofit, every university is getting the same benefit? It's at most a great far marginal issue. I just don't know if that's what they're worried. They're worried about divisiveness. They're worried about the people bringing in religious differences and religious controversies into the initiative process. I don't think they were dealing with sort of these kinds of carve-outs. But again, there's only 2 cases on point.
And it's not just a carve-out. This is how the law is applied. If it is looking at the mechanics of this proposed law makes that clear, which is it repeals the current prohibition on rent control, institutes a broad mandate. Essentially, all residential units are rent controlled unless there's an exception. And if there is an exception, then you are outside of the regulation. So when religion puts you outside of the regulation and puts religious uses, benefits religious uses in a way that secular are not, that is what gives rise to the debate or the concern for debate. And in Collins, there was no record evidence of, yes, there were debates, and that's when and incited religious discussion. It was the potential. And I want to go back to the purpose of
Collins was a huge, basically, exclusion from all laws for any religious entity. And even the contraceptive one had, the court sort of had to strain to find I mean, I don't know, it just seems like we're extending the religious thing. Anytime something carves out an exemption for religion, it can't be an initiative. I don't know, it just seems big.
It does more than that, Your Honor. It doesn't just carve out religion. It makes religion the operative factor in determining whether a regulation applies or not. And that's why it's
to your other, I think this one we understand. Can you move to, because I am caught up in the takings issue too.
Sure. So to discuss the takings issue, I'd like to begin by explaining what the petition proposes to do. And although it's referred to as rent control, and many may believe or understand rent control to prevent exorbitant rent increases year over year, this petition actually does something different. And what it does is it freezes rents at their current rate and only allows for adjustments based on either inflation or 5%, which is ever lower. So what it doesn't do is provide landlords, property owners, those mortgage lenders, it doesn't provide those people, those with any ability to recoup costs or to recognize a fair net operating income for that property, that is their property, which is then capped. And the way that it's capped is that you can only increase the rent year to year, essentially based on inflation or 5%. So the property interest there is the value in the individual's property.
But if you're assuming that right now their landlords are charging market rates, so they're building in their current profit structure, whatever, and now you're going to have this limit on the 5% or the cost of that builds in something, right? It may not be building in enough, but it's building in from an existing structure that allows landlords to make money.
It's only building in an adjustment for inflation. And so if inflation's at 10%, this petition would cap your adjustment at 5%. And that's important because what it doesn't build in, which is constitutionally significant and required in every other rent control law that's either been before this court or that's been approved in any other jurisdiction, is the ability for a landlord to be able to get an exemption from the rent control limit to deal with costs, to deal with hardship. If the roof needs to be rebuilt, that's a cost that inflation does not cover, that the rise in inflation does not cover.
Why can we decide this case constrained by the limits of the facts, or in the AG and her certification, the limits of the facts identified in Yankee 2 and Carney?
I'm sorry, one more time, Your Honor.
How can we decide this issue based on the limited universe of facts that the AG is allowed to take account of under Yankee 2 and Carney, and then we in turn take account of?
Sure. First, it's unclear what facts the AG took account of when she analyzed this particular petition. But even setting that aside, the fact that the test here is whether the petition is inconsistent with the right to receive compensation for private property appropriated for public use. And so we have private property, the value of an individual's property and what they can use, the economic benefit from the use of that property, renting it. And so what we then have, the inconsistency here, is the fact that the ready means of compensation that's established in 40P right now, which says if rent control is reinstituted, you're able to essentially get the delta between the market rate and the rent control rate. So the inconsistency is facial on its face, which is you are no longer able to have that ready means of compensation when rent control is applied. But the problem goes...
The legislature could repeal that at any time.
Absolutely.
And that wouldn't be a taking.
But the voters cannot through Article 48. And here, if...
No, but in order for it to be a taking, you have to have a property interest in that. And I don't see that.
The property interest, Your Honor, is the interest, the economic value of the individual's property, the property that they own and what they're able to do with that, renting it out. So what this does, eliminating 40P in its current iteration, what that does is eliminates the ready means of compensation for those individuals whose property is affected.
But right around the country, this has been deemed legal, except for they may have more exceptions than we do. In New York, Washington, California, right? So those exceptional circumstances, they may still be able to sue and bring a claim down the road, right? I mean, we're looking at the generality, not whether there's a specific unconstitutional taking because your house burned down and you had to do something. That's a whole different story, right? They can still sue for that later.
Sure, but at the Article 48 certification stage, The question is whether the petition is inconsistent with the individual's right to receive
On its
compensation.
face, on its face.
On its face, and here it is, and for two reasons. One, the elimination of the 40P ready means of compensation, and two, in all of the rent control schemes that you were just referencing across the country.
I don't see how the 40P is relevant. I mean, let me give you an example. Minimum wage, right? So the legislature raises the minimum wage. That doesn't make it a taking if it lowers the minimum wage. A statute that provides, that's a statutory benefit. That's not a constitutional benefit.
It is a statutory benefit that's been in existence for 30 years.
So what?
Exactly. The so what is, that goes to the expectations, the investment-backed expectations, but it's also, like in Domino, the ready means of compensation, where when your property is appropriated through rent control, the ready means of compensation is directed through 40P. And when that is eliminated, this goes a step further. It eliminates 40P, but then it also eliminates any way to get a fair net operating income, the constitutional safeguards that all of the other cases concerning rent control throughout the country have included. And that's a huge distinction here, because what this petition does not do, and why it is inconsistent on its face with an individual's right to receive compensation for appropriated property, is it does not allow those individuals to adjust rent based on the costs that they are incurring. That has nothing to do with inflation from a consumer's perspective. And if I see I'm over time, but I've got two more arguments to quickly go through. If
Oh, you think you get more time because everybody else?
absolutely not, Your Honor.
Go ahead. Go ahead.
I'd just like to address the relatedness argument really quickly, which is this petition, it is the purpose, and this is important, is looking at the common purpose of the petition, which is protecting tenants, or the purported purpose is protecting tenants. And the way that the petition proposes to do that is by installing essentially rent control or caps on rent increases. What it also does, though, and why this is a problem for relatedness, is that the petition also essentially bifurcates short-term rentals, and it exempts short-term rentals of 1 to 4 or 13 days, and then any short-term rental that is 14 days to 31, rent control will be applied. And what that means, in the simplest example, is a vacation rental on Cape Cod, that when one is thinking about rent control, no one's thinking about a 2-week Cape Cod vacation rental, but that's exactly what this petition would be doing. It's focusing on long-term rent stability, which is its stated purpose, but it's also targeting short-term vacation rentals, which has nothing to do with the stated purpose. And then very briefly, moving on to the summary is invalid on its face, and I know that this court has discussed the summary issues on Monday and how important the summary is, not just for voters in the voting booth, but also those voters deciding whether to sign the petition in front of a Dunkin' Donuts months before the election. And here, the fact that the petition in the summary, the petition proposes to repeal the current prohibition on rent control in Massachusetts and replace it with essentially its opposite. And the fact that the summary does not alert voters to that major change in the law, even suggest to voters that's what's happening, that's what makes the summary unfair to voters and does not equip a voter with enough information to make an informed decision, either signing the petition or at the voting booth. And if there are no further questions, I'll rest in my brief and request that the court strike the petition. Thank you.
Thank you. Okay. Attorney Fisher-Groban.
Good morning, Your Honors. Phoebe Fisher-Groban, Assistant Attorney General, on behalf of the Attorney General and the Secretary. The Attorney General properly certified and summarized this petition because it's a rent control measure. It's not about religious matters or religious subjects in the ways that mattered to the delegates at the convention or the ways that this court has discussed in its cases. There are also no officially noticeable pre-enforcement facts that demonstrate that on its face, this law would cause the kind of severe diminution in property value as compared to the residual value.
Can you skip back to the religion piece? So this measure is very different from the one in the opinion of the justices because it explicitly references religion, and the excluded matters include matters relating to religion or religious institutions. And this one explicitly mentions religious purpose land, and then it explicitly causes whether the statute to apply or not as to whether it is solely for religious purposes, a term that it doesn't define. So how is this not actually exactly what they said, which is that they do not want any measures that relate to religion or religious institutions?
So the delegates of the convention discussed not wanting to bring religious fights into the political discussion, not wanting to bring religious subjects, religious matters into the discussion. And then in opinion of the justices and Collins, unfortunately it's a limited universe of cases, but it does provide guideposts. And those cases, in opinion of the justices, that law was about permitting the prescription of contraception to married couples, a subject on which presumably folks of certain faiths have very strong views about. But the court said, you know, this law is a secular measure. It's about a secular subject matter. And so it does not relate to religion in the way that we're concerned
But what the court actually said is everything kind of relates to religion on some point, on some level. So we're going to be simpler here, and we're just going to say, even though people might have a lot of religious thoughts about this one doesn't turn its application on religion. It doesn't mention religion. So we're going to say that's good enough. So why should the test not be quite simple like that, right? Explain how we're supposed to apply a test that says, well, you can explicitly mention religion, and you can actually have it apply or not depending on religious status. But we're going to make a judgment about whether it's sort of controversially about religion. How would the AG herself navigate that? Like the Collins exemption for religious organizations was too much, but this one's okay.
It's a question of degree. Collins, if the test were simply, does the law on its face use the word religion? Does it say religious institutions? Does it use those words? Is that enough? Collins would have been an incredibly simple case. But it was not. Instead, the court assessed kind of the nature of the law, and that's where opinion of the justices come in. The court said, this is a secular law. Then in Collins, the court looked at the facial effect of the law and said, what does this law look like? What is it trying to do? And there, that law was doing two things. It was adding, or rather, it was a referendum. So we're talking about the amendments to the law that were the subject of the referendum. It was adding sexual orientation as a group of people who would be protected under Chapter 151B, and it was creating, to Justice Kafka, I believe's point, an incredibly broad reworking of the exemption for qualified religious organizations that would basically newly allow them to engage in pretty much every type of prohibited conduct as an employer. So the court looked at that law and said, this is a significant piece of this law that creates a significant reworking of the religious exemption for religious organizations only. Here we have a law that is, the purpose of it, it's a secular law, which is rent control. And then it excludes a variety of other types of rental units that presumably do not have the profit maximizing motive that a lot of other landlords do. So this includes small owner occupied units. It includes units subject to regulation by a public authority. It includes short-term rentals. It includes units in facilities operated solely for educational purposes, nonprofit purposes, religious purposes, newly constructed units. So unlike in Collins, this exemption for units that are operated, so it's an exemption for rental units in facilities that are operated solely for religious purposes. It's one of a whole host of exemptions.
But it's in its operation, it's going to require courts, at least, I don't know who else, to decide what does it mean for a unit to be used solely for religious purposes, which was basically the subject of a U.S. Supreme Court case yesterday, which has already been referenced in the earlier argument, where it was claimed that Wisconsin was not properly applying its test in a labor-related statute about, I don't think it used the word solely, but it was like primarily for religious purposes. And there can be really difficult judgments about what is or is not primarily for religious purposes. And this law is enacting a new one of those here, where someone's going to have to decide, this, Zen center that has dorms, like, is that solely for religious purposes? The, such and such religious building that has, religious school. There are going to be line drawing questions that are now created by this law.
Yeah.
That's true. But the question is whether this kind of relates to religion in the ways that were significant to the delegates. And also, when the Attorney General is evaluating these laws, Article 48 is meant to be construed in a manner that allows the people to put questions to the voters. And this is really, in effect, a rent control law. And it did seem to matter to the court in Collins that the new reworking of the exclusion for religious organizations in the Chapter 151B amendments was a really significant part of the law. It could have been enacted on its own, those provisions. All this law is doing is saying we're enacting rent control and we're making no change to what religious facilities can do. We are not altering their legal status. We are not altering their rights at all.
It seems to me, though, that you keep saying that that this is Collins, but you know, broadly speaking, Collins was concerned with a public debate over whether or not religious institutions should receive preferential treatment. And when you have a campaign here where why is that not the same concern where you have a rent control campaign where that it seems to be that based on how it's written, it's going to invite debate over whether or not religious operational housing should receive preferential treatment.
And here's why it matters that it's such a small part of the law. That affects this question of whether it will invite political discussion of religious subjects and religious matters. And it's also not clear on the face of the law how this benefits religious organizations, because all this exclusion does is that facilities that contain rental units that are operated solely for religious purposes are excluded from the rent control law. It's not clear who the property owner is in that circumstance. All it's saying is that that landlord could raise rents for the rental units in that facility above the caps that are in the law. So if it's a religious tenant but a on its face, this is not kind of the clear, extensive, significant exemption from discrimination laws that existed in Collins. And that matters.
That's not really the Article 48 test. I know we only have 2 cases, but Article 48 is pretty clear in its terms, and we have this history. We know why the exclusion was entered, because it would, the delegates didn't want political debate over religion. And it's so much simpler that if it says, you are exempted from this law, whatever it is, because solely on the basis of religion, that sounds like it's related to religion.
But again, in Collins, the court didn't accept such a kind of straightforward test. It didn't say if it says religion on its face and it's creating an exemption from the law for religion, that's enough. The court didn't say that. And there are a variety of ways in which this case is quite different. And it's a matter of degree. And the matter...
Let me just quote Collins from you. It rejected the law because the provisions of Chapter 516, I guess the proposal, make an institution's connection with religion the sole factor in the application of the exemption. Isn't that the sole factor here for this exemption?
It's not. And that's because there are a variety of different exemptions.
So if Chapter 516 had added other institutions that could also discriminate, then it would not relate to religion? Is that what your reading of Collins is?
Well, I will say that Collins says, and this is at 848, it says, let me see if I can find it. It says here, I'm having a hard time finding the quote, but it says that it matters that it's being given special treatment to religious organizations in a way that are not given to any other secular organization. So it does matter here. This is a big difference from Collins. The fact that here the exemption is kind of this broad category of landlords whose tenants are probably less likely to require the protections of a rent control law because their landlords don't have the same profit maximizing motive. So it was significant in Collins. And again,
I mean, don't we have to do some line drawing? Because if you read the express language, no measure that relates to religious institutions. So that is like unbelievably broad, right? Relates to, it doesn't say mentions or relates to. So We got all kinds of laws that have religious exemptions to them. The Dover Amendment. We've got, so there has to be some narrowing concept. It's not just that the word religion appears in it, because then we got to make sense of relates, because relates is incredibly broad. So I don't see how we avoid some line drawing here. We can't just simplistically say, oh, the word religion appears, so we're out, right?
Yes, Justice Kafker. And that's where, so in the power of the courts exemption, there is kind of this ancillary, if something is just an ancillary provision or a small part of a measure, it doesn't relate to the power of the courts in the way that it should be excluded from the ballot. Here,
What's the reason for that?
well,
What's
because
the rationale for that rule?
the rationale there is that because so many statutes implicate or relate to the power of the courts because they create new causes of action.
Right,
for
and
enforcement.
how does that rationale apply to this exemption?
It applies to this exemption, or it's a different rationale here, is that if the concern is political debate, it matters for line drawing purposes how big of a part of a law the religious provision is. So here, where you have a really, really small, minute aspect of the law, and it's not even clear what additional work this provision does on its face, in addition to the nonprofit aspect of the exclusion, that is not enough
But
to
we have
keep-
to take the initiative as it comes. It doesn't just list nonprofits. It could have done that. It doesn't. It lists religious institutions, solely religious.
Well, then, query whether if it didn't exclude religious organizations, then perhaps would it apply to and would it relate to them in that way? That's why this is a matter of degree, because, for example, a law that
Well, it
would,
wouldn't apply to them solely because they're religious. They'd have to be nonprofits, which
That's-
is a different thing.
that's true.
So I don't understand the problem with the test you're articulating.
The problem with
Well, why would it be a problem if this initiative had actually said nonprofits, as people posit it must have meant? I think that might have been okay to certify.
but query then whether there would have been discussion about whether rent control should be imposed on religious organizations, which is to say whether the government should be telling religious landlords what they can charge their tenants. The point I'm making is that there must be line drawing here, and opinion of the justices and Collins stand for the propositions that we look at the nature of the law, and here the nature of the law is a secular one, and we look at the facial effect of the law, and we look at the importance of the kind of religious provision to the rest of the law. And in Collins, it was quite important.
Well, it seems that you continue to say that the word religious is not doing any work here. And I guess I just still stuck with, if a unit that would otherwise be subject to the law is not, because it's related to religion, how is that not giving preferential treatment to that category of units? And so, I mean, that's just a basic question. I mean, would you agree with me that if that were not, that those units would be subject to the rent control law?
They would be, though I will push back on the notion that it's giving preferential treatment to, because then the idea is that that unit could be subject to above CPI or 5% rates. In other words, it's not quite clear on the face of this how this actually impacts property owners versus
Excluded
tenants.
as nonprofits anyway, right?
Precisely, so it may just do
Maybe.
additional work.
Yeah, they might be. They might be.
Right, and I think that again goes to the ancillariness of this provision, and that it is not a sufficient basis under line drawing that has to be done to keep this rent control question from the people, to allow them to vote on it. I see that I have quite limited time. I'm happy to answer more questions on religion, otherwise make a few points on taking, or if the court has.
Can you address the short-term rental just quickly? Because it does seem a little, so if the 2-week rental, if you're renting for a month, you're subject to the, that seems complicated. Is that a sort of a separate question?
It's not part of the relatedness inquiry. So the relatedness inquiry looks at the face of the law, and it determines whether all the provisions of the face of the law are related to a common purpose. And here they are. in Wiener, this court was clear that the impact of a proposed measure on other laws is not part of the relatedness inquiry. So the fact that there is another kind of regulatory system that also applies to short-term rentals doesn't mean that on the face of this law, all the provisions are related to rent control. And also that goes to the scope of the law. What is the length of the tenancies that it's going to apply to? It's also important here too, the purpose of the relatedness requirement. It's really clear what the scope of this law is. If a voter has a concern about the scope of the law, they can vote no, but that doesn't mean that this law includes unrelated subjects.
They understand it, because doesn't this also relate to the summary when it comes to the short-term rentals? Because you might be a member of the 1% that has your house in West Tisbury, and you might think, what do I care about rent control? Let me go ahead and vote for it. But now you can't rent your weekly rental for $30,000 a week when you could before.
Well, maybe if you're renting it now for $30,000, you certainly still can. And in fact, you can increase it. And that's another important part of this law.
What if you're not?
On the face of this law, it's quite clear the scope of what it applies to. So in the summary, it specifically includes all of the excluded types of units. So that property owner could look at the face of this and say, oh, okay, the scope of this includes my West Tisbury rental. Maybe I'm not in favor of it after all. But the relatedness question is, are all of the provisions of this measure related by a common purpose? They are, controlling the increase or limiting the increase in rentals. And on the summary, it's clearly on the face of this summary. It's not hidden, it's not confusing, it doesn't make the summary unfair or inaccurate. It is both fair and accurate.
Okay. Did you get to cover what you wanted to cover today?
Well, on the takings point, if the court has any questions, I'm happy to answer that. I see nods of no. I will just say that at the certification stage, there are not sufficient officially noticeable facts. And as the court concluded in Carney, Abdo, Yankee Atomic, a takings analysis requires a very fact-dependent inquiry that can occur in a post-enactment challenge, but we don't have sufficient facts at this stage to keep this law from the ballot. Thank you very much.
Thank you.